To be a 30,000 foot view overview. I'll say that from the start. I won't get into specifics probably because each person is unique. Each person owns what they own, owns what they don't own, has individual circumstances. We're going to give a good broad overview. About me, I'm the co-founder of Dillon and Elliott PSC, a cornerstone law group in LaGrange, Kentucky. My partner Clint Elliott and our firm assists the church as kind of outside in-house counsel. So we're thank you for that partnership. We enjoy that. My practice largely focuses on nonprofit and church law, constitutional, religious liberty issues, business and corporate solutions, and estate planning and elder law. So those are my areas. That may seem broad, but honestly, a lot of them interact with each other. So I'm a proud girl dad. I have a 3-year-old and a 1-year-old. They're about to be in bed, so I'm getting out of bedtime duty, which is honestly not that bad. And then I'm a deacon at Newcastle First Baptist Church in Newcastle, small Southern Baptist church in Henry County, which is where we live. So I figured we'd start off the conversation with scripture, right? Proverbs 13:22 tells us that a good man leaves an inheritance to his children's children, but the sinner's wealth is laid up for the righteous. Thought that was very deep. And then I just love this verse in 1 Peter 4:10. As each has received a gift, use it to serve one another as good stewards of God's varied grace. I just love that word steward in Scripture. That's what we're called, to steward, not just the grace, but also our possessions, which is really what estate planning is about, right, in elder law. So topics to be covered, we kind of talked about this. Wills and living wills, trusts and estates, power of attorney, healthcare surrogate, and then we're going to get into some elder law, nursing home requirements, and long-term care planning. So really the first 4 bullets there are what you would refer to as estate planning, and then the last 2 are really elder law. Those are 2 distinct, yet they overlap quite a bit, practice areas in the law. Whereas the estate planning is kind of more about, financial affairs, transfer of assets upon death, versus elder law is really more focused on this long-term care aspect. So think about when I say long-term care, I mainly mean skilled nursing facility, nursing home. There are different levels of care, and we'll get into that a little bit. But that's more. Sometimes you hear of Medicaid planning, Medicaid. That's that area, right? So we will get started. Estate documents every person needs. So this is one of the slides I really want you to pay attention to, right? You need 4 documents. This is just general, and again, this is all unique to each person depending on what you have, what you don't have. Each person needs a will. Each person needs a living will. Each person needs a durable power of attorney. And each person needs a medical power of attorney or a healthcare surrogate. Those terms are usually used interchangeably. So a will, a living will, a durable power of attorney, and a medical power of attorney, healthcare surrogate. And we'll get into each of what those mean and what each document means. I'm not going to ask for a show of hands to who has these documents, who doesn't. I'll make an admission, I don't have them as an attorney, and that's just the way our stuff is structured. But those are the documents that every person needs, because when you don't have those documents, and we'll get into that, that's when trouble forms, right? Especially in everybody's situation. Could have blended families. You could have sibling strife or children strife, I would say. That's the most common, what I see. So these documents will really streamline the process. So let's get into them. So first thing is a last will and testament. So a last will and testament, and it's just called a will, it determines who receives assets at your death, who's going to serve as your personal representative, when you might have heard as your executor, executrix. That's the term under the statute is personal representative, but executor is fine. If you have minor children, who's going to serve as a guardian? You can name a person to serve as guardian that the court will honor. Who pays taxes? When I say who pays taxes, I mean inheritance tax and estate tax. So Kentucky has what's called an inheritance tax. They tax depending on classes of beneficiaries. So if you leave your property to your children, to your parents, to your siblings, they don't owe any tax. Kentucky said they're Class A beneficiaries, they don't owe any tax. If you
repeat that, please.
Kentucky has an inheritance tax. Kentucky taxes it depending on who gets it. So if you leave it to a Class A beneficiary, which is your children, your parents, and your siblings, they don't owe any tax. Kentucky exempts them from tax. If you leave it to your nieces and nephews, they'll have to pay a small amount of tax. If you leave it to people you don't, if you left it to me, I don't think I'm related to anybody in here. If you left it to me, I'd have to pay tax on it. So that's the Kentucky inheritance tax. There's also the federal estate tax. That's the federal government. With the federal estate tax, they have a tax exemption amount, which is currently almost to $12 million. So if you have less than $12 million, you don't have to pay federal estate tax.
Don't worry about that part.
If you have over $12 million, you need to come see me. So if anybody in here has over $12 million, you need to structure your assets. And if you're married, then it's double that, right? So it's $24 million. So with portability. So a lot of people, most Americans don't have to deal with the federal estate tax. Now I will say that President Biden and his administration have come out and they said they want to reduce that down to about $5 million. So that's going to capture some people, think large landowners maybe that have farmland. You're getting up there, right? So it's always, and these laws are always changing and shifting. But as it currently stands, and that law that hasn't come out of committee yet, but that's where we currently stand. So, yes, ma'am.
You said that, you mentioned the people who are exempt from the inheritance tax, first degree or whatever you said.
Class A.
Class A, okay. There is a custom in our church that people like to leave money to the church.
Mhm.
So would there be tax on the amount left?
No, because the church is a nonprofit. This statement that I'm about to say is, I think, what really gets people. If you do not have a will, the government gets to decide who gets your money. I'll explain that, but a lot of people don't like that, right? You don't want the government telling you what to do. So, if you don't have a will, you have died intestate. Testate meaning you have a will, intestate meaning you do not. If in Kentucky, if you die without a will, your property is dispersed to the following classes of persons in order. So, first is your children, then it's your parents, then it's your siblings, and then it's your spouse.
Wow.
So I always ask the question: who here thought that their spouse automatically gets everything that they own at their death?
I thought that did.
Well, that's wrong.
My wife takes it all now.
Well, I have no comment on that.
So one child, 100% to them.
Well, and so I'm going to qualify this. There are ways that the spouse can get. The spouse can get up to a third of the real estate and a half of the personal property, but they don't get everything, right? So under the intestate succession versus your children. So if you have a child, they're going to get half your property, even if you're married. And then if you don't have children, if you have parents living, they're going to get half. If you don't have parents, your siblings are going to get half. And only then would your spouse come into
Now, this is only if you don't have a will.
Right.
If the government steps in.
This is only if you do not have a will. If you have a will, disregard this. Okay. Does that make sense?
Yes.
Okay.
Can the will ever be changed?
Yes, will can always be changed, but you cannot change it just by scratching out something in the initial.
No, I mean, can your family do it?
No, you have to change your own will. And you can't I can't prepare you a will. We sign it, you take it home, you say, you know what, I actually didn't like that, and you scratch through it and initial it. That's not good enough in Kentucky.
I think she was asking if a will could be contested.
Yes.
Yeah, after you die, yes, certainly. Will can be contested on testamentary capacity issues. You didn't know that, meaning you didn't have the capacity to know how you were leaving your property, who you were leaving your property to. That's one of the things. It can be contested on undue influence. So the classical scenario there is, think of an elderly person that may be slipping into some memory care issues, and you have a person come in. It could be a child, it can be a a caretaker come in there and start asserting some undue influence to where the elderly person changes their will to leave them everything. I've been involved in one of those things.
What about a child who just suddenly shows up you didn't know you had?
Each unique consideration. is
So
unique.
they might be able to get somewhere with it.
Maybe, depending on what the will says.
Right.
And how your property's left, certainly. Yeah. Yeah, so in a will contest, yes, just during your lifetime, you're the only person that can change your will.
Right.
Is what I thought the question was. But after you die, yes. Now, in a will, you can have what's called a no contest clause that says if you do contest the will and you lose, you get nothing. So that's, some people in their will leave, child A, I don't know, $1,000 or whatever, and then if they contest it and they lose, they don't even get the $1,000, right? So building in some type of benefit to say, you know what, okay, I've had enough.
What's the time limit on that contestation?
Well, I mean, really any time, but I mean, you have 10 years after your death to probate a will. Meaning you take the will up to the district court, to the probate court here in Jefferson County, you take it to Jefferson Probate Court. You have 10 years to do that. You have, after the will has been probated, basically someone can challenge it up to 2 years. Challenge the probation of the will. And typically these things are moving pretty quickly. But does that answer your question?
Yes.
Okay. So typically 2 years after you die. Now again, this is only if you don't have a will, right? So we're going to throw that out. This is a good point to stop, and I don't have a slide for this because it's easier to explain than I guess really read. There's a distinction between probate assets and non-probate assets. So probate is the process to where you take your will up to the court, you get it admitted, and then there's a whole statutory process that you go through with notifying creditors. Depending on that, paying out creditors, and then dispersing out the assets to the people that are named in your will. Okay? So there are a distinction, though, between probate, what goes into that process, what assets are covered in that process, and what assets are outside of that process. So it's easier to say everything's probate unless it's not. Okay, we'll start there. And what things are not probate are, think about retirement accounts that have beneficiary designations on them. So if you have a 401k, you have an IRA, a Roth IRA, you filled out something at your broker or at your work that says, if I die, I'm going to leave everything to X. That's a beneficiary designation. So that beneficiary designation is going to control regardless of what your will says because it's outside probate. Another example of that is real estate if it is jointly owned. So the classic example is my wife and I own our house as what's called joint tenants with right of survivorship. Now that's a fancy legal term and depends on what the deed says, but that's a term that meaning upon the death of the first of us, the real estate just automatically passes to the other. So if I were to die, my wife automatically receives our property, our real estate.
But doesn't that matter if both names that were on the original bill of sale?
Deed.
Well, it means it matters on how the deed says you hold the property. So you can hold property in various ways. Joint tenants, tenants in common is what that is referred, which means each person owns an undivided half interest typically. Or joint tenants with right of survivorship, meaning each party owns the whole, and then upon the death of the first, it goes to the second. So it depends on what the deed says. Now, I don't know. I haven't seen any of your deeds, right? So I don't know how you own the property. Most recently, I would say probably from the 90s on, maybe early 2000s, are joint tenants with right of survivorship. Some of the older deeds that I've gotten into, it was more common to do tenants in common, and in that case, it's not automatic, and it goes under your will. I have a case right now that I'm working on where the husband and wife they each held an undivided 1/2 interest in the property. Husband died like 13 years ago. His will says that he wanted half of his half interest to go to his wife, and then 1/4 of his half interest to go to one son, and 1/4 of his half interest to go to the other. And they didn't know that, so now we're 13 years later, and everybody's confused and we're like, okay, well, who actually owns the property and how do we get this sold? So that's to say probate, non-probate, okay? Probate is under your will. Non-probate is retirement accounts, beneficiary designation, life insurance. They have a beneficiary designation too, right? And real estate. Those are really the main three things that are non-probate. So no matter what your will says, those are going to pass outside of your probate. And honestly, that's the majority of Americans. That's where most of your assets are at, right? You own a home, your real estate, and you have your retirement accounts that are beneficiary, and you have some life insurance. That's the majority of Americans own their assets. So the majority of assets are being passed outside probate.
Well, like, my husband has died, and the home came to me automatically. But, and I have it set up right now to go to my remaining son.
Mhm.
So there shouldn't be a problem, should there?
Well, how do you have it go into your remaining son under your will?
Yes.
So that's going to be in probate because there's no joint tenancy with right of survivorship. So the only time real estate passes outside probate is if it's joint tenancy with right of survivorship, that right of survivorship. You had that with your husband, it sounds like,
Well,
but you don't have that with your son.
well, since I had two sons, and the second son has died recently, and I redid my will and made it so that it went to number one son, because number two son has died.
Right, and so that's according to your will, so it's going to be included in your probate estate.
So I should not have any legal, like,
Well, and I can't really opine on specific instances without establishing an attorney-client relationship. That's where I would leave that. I'd have to review documents, deeds, wills, the probate stuff, etc.
well, it's been done within the last year, so it should be up to date, shouldn't it?
I would assume so, but I never know unless I look at it, right?
Okay.
So, any questions on that? That's a difficult concept. It was for me at
It
least
is
when I
a
was
very
learning.
difficult concept,
Right.
but you're saying like life insurance, that doesn't automatically go to your remaining relative?
I'm saying that life insurance will go according to who you've signed the form to say it go to. So if you have filled out a beneficiary form that says, I want my life insurance proceeds to go to my son, that's who's going to get it. No matter if you put it in your will, and the will says, I want my life insurance proceeds to go to Matt Doan. Right? I'm not going to get that because you have this beneficiary form.
Okay.
Okay? Because it passes outside probate.
But do bills have to be paid out of that first?
I mean, there's so many different things that you're kind of getting into that, I mean, I can't really answer that.
I'm just, I want to know how, do bills, like nursing homes, that's one of the big issues with any of us would be concerned with, because,
We'll get to it.
okay.
Okay? So that's wills. Let's get into living wills. So you have
That's a big issue with this.
last will and testament, you have living wills. A living will expresses your end-of-life desires regarding life-prolonging treatment and care. Meaning, do you want to be artificially kept alive? Do you want to be on a ventilator? Kentucky has a statutory form that the General Assembly has laid out and said, this is an acceptable living will. It's very bare bones, though. It's literally check here, check here, check here. This typically comes into effect when you're terminally ill with no hope of recovery, or you're in a vegetative state with no hope of recovery with no brain functions. And that has to be certified by 2 independent physicians. So it's not like, you're in a coma, but there may be a hope of coming out of it, but somebody gives you this document and they say pull the plug. That's not how this, you have to have 2 physicians sign off and say, listen, there's really no hope of recovery. So that's what this document is. Probably some of you have been in the hospital and they've asked you, do you have a living will? You say no, and they may have given you something to fill out at that time. Maybe not, but this is a document that I prepare for clients, for example. I have my own document. In the living will, basically you name someone, you name a healthcare surrogate, and you tell them, yes, I want to be kept alive. No, I don't want to be kept alive. or I want you to decide. Those are kind of the three options that you have. If you don't have a living will, then a hospital really, has to keep you alive until maybe there's a court action that's been filed. So, I always tell clients too, as an aside, this is really the document, this and the will, but this is really the document you want to talk to the person that you're naming, right? You don't want to just elect some stranger, or even maybe one of your child, but to the exclusion of another, to say, hey, I want you to make the decision that I do not want life-prolonging treatment. I want to be let go. But then you don't tell your child until you're at that stage, right? So really, overarching theme of all this is be open and honest, typically, with the people in your family about what your decisions are, and that's going to limit the friction when we come to that place.
So if you have a living will, do you also need a healthcare surrogate?
Well, so those terms are sometimes used interchangeable. I don't use them interchangeable. A living will is end of life. A healthcare surrogate, a medical power of attorney is what I call it. That is for medical decision when you can't make the medical decision.
Oh, like if you were home or something.
So let's say the classic example, my wife and I watched The Good Doctor. I don't know if you're familiar with that show.
Yeah.
They always put the person under anesthesia. They go in and, oh, well, there's a problem. Then they have to go back out and talk to the husband or the wife or the daughter or the son. Well, they have the medical power of attorney. They're the healthcare surrogate. So they can make that medical decision for them while they're alive. They don't have the capacity to do so. A living will is end of life. You are on a ventilator. You are being artificially kept alive. Do you want to continue to be kept alive? That's the distinction. Does that make sense? The two distinctions. Okay.
Can you put limits on how long they can keep you alive?
I've never seen it done. Not saying you can't.
I mean,
Yeah.
Yeah.
I don't want them pulling the plug on the first day.
well, I
Yeah, give me a
I
little
guess that's
time.
what I might say. I mean,
Yeah.
can they hook you up, we'll say, for a week?
Mhm.
And then say that's as far as it's gonna go?
Yeah, I think you could do that. Now, if I'm the general counsel for the hospital, or if I'm the doctor and I get that living will and they say, well, he wants you to pull the plug, but not for a week, I'm going to send that to my general counsel and I'm going to have them give me an opinion on it, right? I would think that would be fine. That's really giving your surrogate the discretion, for that week. I want to be kept alive. For 6 months, I want to be kept alive. And then after that, I don't think I would have a problem with it as an attorney, but other attorneys may. Right, I get where you're coming from. Right, you never know when the Lord's going to intercede on your behalf. Right, so
Might be the best time of your life.
right, you never quite know.
You could be having an Indian,
You never quite know. So, most of my clients, they go with, I don't want to be artificially kept alive, but I'm going to leave it up to the person that I'm naming's discretion. So it's typically a spouse or a child. You're saying, listen, I don't really want to be kept alive, but I'm going to let you decide for me, right? Because I don't really care at that point because I'm end of life.
Yeah.
So, any questions about living wills before we move on? Yes,
Do
ma'am.
they use the physician order of life-sustaining treatments anymore, or is that no longer? Because, living wills are trumped all the time
Mhm.
by medical professionals, by, family members or anybody,
Mhm. Yeah, if you have a most document, if you have that, sometimes it will. It just depends on when they were executed, how they were executed, etc.
But isn't that a recorded instrument where a living will isn't, right?
Living was not recorded, right?
Yeah, and if you have a recorded document, then it has to be that way. Like, for example, the DNR, if you
Mhm.
don't want a DNR sign
Mhm.
on you, you would put that in a recorded instrument rather than in a living will, right?
It just depends. Some people don't. A lot of people keep their DNRs in like an ice chest. Have you ever had, and I didn't know this till recently, because I don't do that, but with the DNRs, typically the EMTs, the EMS workers, they know to go check your freezer for these documents.
What's a DNR?
Do not resuscitate.
Okay.
So if you're
That
coding,
means
Sorry, I didn't know
in the
that.
state of Kentucky, what that means is you've been stripped of your right to live.
Okay.
yeah, it means they're not gonna resuscitate, and they're open to
You won't even
damages.
get your diabetes medicine.
Yeah.
And if they know that if an EMS worker knows that there's a DNR or a doctor or a nurse, and they still resuscitate you, that's opening them up to damages. So that's a very serious document. that I do not ever, I don't deal with that because I mean, that's really your, and you can get those from the medical professions, from the DNRs. So very rarely would I.
Freezer.
So, yeah, I
Did
didn't
everybody
know.
know what a DNR was, or I was the only stupid?
No, I didn't.
I'm the only stupid one.
My mom.
Do not resuscitate.
Well, we deal with individuals with disabilities.
Yeah, we do.
We have to know all that stuff.
Yeah.
For now on, just don't do initials, because I don't know what they are.
Well, if I said do not resuscitate, would that have made any more sense? I don't know.
So we'll move on to the general durable power of attorney, POA, that's power of attorney.
Got
Okay.
it.
All right, power of attorney, that's the abbreviation I'm gonna use.
I like it.
This is typically called your financial power of attorney. This allows your attorney in fact, which is your power of attorney, those terms are the person that you name to handle your financial affairs for you. Durable, that word, only means that the document survives your incompetency. So if you sign a document today, if I signed a power of attorney today and I name my wife as my attorney in fact, that document goes into effect immediately. She can handle my affairs regardless if I'm competent or not. But if something were to happen and I become incompetent, meaning I'm in a vegetative state, I'm in a coma, or something happens and I have a brain injury, that document still stands, that incompetency. That's what durable means. It needs to have that language in the power of attorney. It has to be on the document to be durable. And so I always say, choose wisely who you're naming as your attorney in fact, because it goes into effect the day that you sign it.
Presumably, these things have to be notarized, and presumably the most recently signed document would be the one in force in the event of whatever.
Yeah, so under the Kentucky Uniform Power of Attorney Act, that's been amended. That was adopted a few years ago. It's been amended since. Under that, a power of attorney is effective if it is notarized. So you don't have to have a witness. Whereas with a will, for a will to be self-proved, it has to have two witnesses. Self-proved meaning you don't have to present testimony at court that, oh, I saw Matt sign the will. It was his. He was fine that day, and that was his will by signing it. That's what self-proved means.
So if somebody has a general durable power of attorney, say I'm a widow and I have a daughter. So let's say I gave her durable power of attorney, and next week she decided, I don't like something mom does, I'm gonna take over her finances. Could she do that?
Well, they have a fiduciary relationship with you, so no, they can't just defraud you, right? But you have to be able to know that. And so the typical situation is, what happens if you don't know that they're doing that, right? You don't know that they're defrauding you because you don't have that capacity to know that, right? You have to have somebody else step in. So that's why I always say choose very wisely, because yes, technically she has the power the next week to go change all your bank accounts. Now, she would be liable for that because, if she's using that money to defraud you, right? There's that limitation on it, but it does go into effect.
So she has to be acting in her best interest.
Right. Yeah. So, I always say yes. You should also, if you're married, you still need a power of attorney, right? If you're gonna, and presumably you would name your spouse as your power of attorney, but maybe not always. Presumably, you would name your spouse, and that's just going to allow your spouse. What happens if you're traveling, for example? I've been at multiple real estate closings where the spouse is traveling. Well, it doesn't make sense, and they need to get the house sold, that day. Well, if the spouse has the power of attorney, they can sign all the documents for them on their behalf. So that's.
So you gotta have one going both ways?
Well, you don't have to, but if the other spouse is out of town and the other spouse is local, then you would need the other power of attorney, right? That's what every person needs these documents, right? Not just you or your spouse. Kentucky's Uniform Power of Attorney Act. It's a statute. It was adopted a few years ago. It's been amended a little bit since, but it contains general powers that a power of attorney has, specific powers of attorney, specific powers that a power of attorney has if they're included in a document. So, power to create trusts, revocable living trusts, for example. We'll get to that here in a second. Stuff to deal with your Facebook accounts, right? That was the big thing. All people were dying, and Facebook wouldn't let family members get on there. So that's been a whole new uniform act that's been adopted. So that's what a general durable power of attorney. Just to give you an example, my power of attorney that I use is 17 pages. It's just very all-encompassing. Not saying you need a 17-page one. You don't. I mean, you could have a one-page power of attorney that says I want to have every power that I could have, right? That may be effective on 17 pages because I want it to be all-encompassing, so there's absolutely no questions. So that's what a general durable power of attorney is. Financial. Any questions about that? Okay. Medical power of attorney, healthcare surrogate. We already kind of touched on this a little bit. This names an individual to make healthcare decisions for you if you cannot make them. So again, the classic example is you're under anesthesia, you're in surgery, they go in, they find another issue that they need consent for. You have to have informed consent when you're undergoing a medical operation. So they can ask your healthcare surrogate whether they have the consent to do that operation or not. Typically, this includes a HIPAA authorization as well, just to authorize physicians, medical professionals to release information to you. And I always say name only one person, because what happens if you name your 2 kids and they go different courses? Well, then you got to get a judge involved, and judges don't want to be in that situation, right? They don't want to be deciding whether mom lives or dies because the 2 kids can't decide, right? And this really isn't live or die, but doesn't have the treatment. Let's say the judge doesn't want to decide whether mom has the treatment that gives her a 5% chance to live or not, right? So name one person and have that conversation with them. So those are the 4 documents every person needs to have. I'll stop right here. Any questions about those kind of remaining? Yes, ma'am.
On the medical POA, wouldn't the CARES 311, where you have the list of people who are in charge of you as your healthcare surrogate, I mean, I guess your spouse is first and then your children after that, and I guess I don't really understand why we would need to have a medical POA. I never did really understand that, because if you've got the living will, if you've got your DNR laid out the way you want to die or want things to go, it seems like that's kind of like double doing it or something, because the law.
Well, it might be a little bit. I'm sure those statutes also say unless you've changed it. That's probably, again, under the intestate and kind of like a default. I'm sure that's what those statutes are. So let's say you don't want
a default if you don't have anything.
Right.
I see.
I'm sure that's what those are. They're default if you don't have anything, and that's what a judge is going to have to get involved in to decide, well, who has precedent here to make this decision for mom.
Right.
Whereas if you have that document, well, it's set out for you, and it's valid. That's why.
You mentioned about in your will where you would name the guardian for your minor children. What if that person doesn't want to assume that role? Do they have the responsibility to find the person, or do they just tell the executor, I don't want to do it, and then what, the judge has to decide? Or
Yeah, then you probably have to file a guardianship action for the kids. Yeah. And I mean, any person that you name in any will can decline that role, whether it's executor, executrix, they say, no, I don't want to do it. Power of attorney, they can also say, I don't want to do this. Healthcare surrogate, they can say, I don't want to do it. I mean, they're not going to be forced to make that decision.
Could you give me some clarity on the timing of power of attorneys? As far as, you mentioned you have one.
Mm-hmm.
So how do you have a power of attorney, and when would that go into effect? And why would you need one, or suggest to have one at an earlier period in your life as opposed to later in life?
So power of attorney becomes effective the day you sign it. So that person can act in your stead the minute they sign it, or you sign it. They don't sign it. The minute you sign it, so it becomes effective. Why you would want one? Well, you never know what's going to happen, right? I mean, that's the answer that I would tell you. If you're married, typically you name your spouse, so your spouse can handle bank, transactions for you without you having to be there. Presumably, you trust your spouse and you love your spouse, but you might not. You might not want that person to sign as your POA. The situation if you're traveling, the situation if you become incompetent, if you have a brain injury, you're in a car accident, you have a brain injury, you need to sell the house to pay for medical bills, etc. Well, I mean, you can't do that because you're incompetent, right? But your power of attorney can, because it survives.
So how do you avoid conflicts during the time where you don't need the power of attorney?
Well, presumably you're going to appoint someone that you trust that's not going to defraud you out of money. I'm assuming that's what you're getting at. That's not going to, I mean, that's probably the best answer that I can have you. Presumably you're going to choose wisely on who you're appointing, and they're not going to take advantage of you. If they do, then you have recourse. Obviously, you can go after them. You can file a lawsuit saying they breached their fiduciary duty to you, they breached the power of attorney, et cetera, and go after them. But I mean, presumably you're not going to name the person that's going to do that.
Let me ask you another question in that same line there. What happens if, we'll just say you named your child as power of attorney,
Mhm.
and they get divorced, or they go bankrupt?
Mhm.
Does
I mean, the
that
power of
mean-
attorney
does that
doesn't
mean
convey-
your stuff is in with them?
No. The answer is no. I mean, there's just unequivocally no. It doesn't convey any property rights to them, just the right to make that decision.
You know what the inheritance tax rate is?
Depends on the class of beneficiary. It's a certain amount, then plus a tax over the amount. And I don't have that. There's a schedule you can look. You can just Google it. It goes from Department of Revenue, inheritance tax, and they have a sheet that has the tax rates. All right, we'll move on. This is the last slide I have for the estate planning part. Trust. We want to talk about trust and estates. So a trust, I tried to figure out, well, how can you define what a trust is? A trust is a legal document, and I think I did pretty good, so I'm going to read it. A trust is a legal document which establishes a fiduciary relationship with one or more trustees who hold and disperse property according to the terms of a trust agreement. So it's a document, it's a trust agreement that you sign that details what you want happened, and you appoint a trustee to basically take care of the assets in the trust. That's a very, 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 very simplified explanation. You see down here, there are many different types of trusts for many different types of circumstances. I mean, there's,
Are trusts used a lot by people who are trying to get around inheritance in estate plan? I mean, that's what I hear all the time about how to protect your assets, get a trust in.
So, like I said, there are many different types of trusts for many different reasons. We'll go through this and then I'll answer that question. So you have an inter vivos trust versus a testamentary trust. Inter vivos means that it's effective during your lifetime. So you've probably always heard revocable living trust. May have heard that term. It just means you set it up while you were alive, and it's there while you're alive, and you can transfer assets in and out, etc. It's pretty much always amended. Testamentary means it doesn't come into effect until you die, and it's usually contained within your will, your last will and testament. The classic example of that is like a children's trust. So I have minor children. I don't want my children, they can't receive property until they're 18. But even, when you're 18, you're still not very smart, in my opinion. So at least I wasn't, right? Maybe until I'm 30. So, you can set up a trust under your will that says, well, I want the trustee to hold the money, anything they would get under the will, for their benefit, and then maybe disperse out at certain times. So that's an example of like a testamentary trust under the will. There's also a distinction between revocable and irrevocable. Those are pretty self-explanatory. Revocable, you can revoke. Irrevocable, you can't. Those are just some distinctions. Now again, there's spousal lifetime access trust, intentionally defective grantor trust. Again, I can get into all of them, right? They can be used for different. That's one reason, right, to try to get, I wouldn't say get out of, I would say plan, carefully plan to not pay estate taxes. So, if you have if your estate is over the federal tax exemption, if you have over $12 million individually, or over $24 million with a spouse, yeah, you're going to be using some trust, right? You're going to try to, the name of the game there is get assets out of your estate, so you don't have to pay tax on them, right? We'll get in here long-term care planning. They have a Medicaid asset protection trust, right? So that's a trust that you put money into to help yourself qualify for Medicaid.
I think a lot of people that are here are thinking, or have thought along the lines that if they get bad sick and go into a nursing home, they don't want their estate to be wiped out by the government to pay for that nursing home, and the children have nothing.
Right, that's the next slide.
Okay.
Can I ask you a little bit about this irrevocable trust? Can you alter it after, we'll just say,
Typically, yes. It depends on what the trust, again, it's a legal document. It's basically a contract. Think of it in that way. So, typically contracts have a term in there that says you can amend it, right? So the same way with the trust agreement, trustee would probably have the power. On irrevocable trust, you're typically not serving as the trustee. Revocable living trust, you are. So if you have a revocable living trust, you're typically serving as the funder and the trustee during your lifetime. Meaning you have basically complete control over all the assets in it and the trust document, so you can amend it, whatever. If it's irrevocable, there's like an added level to, and that's typically used for, again, tax purposes or Medicaid purposes, estate planning, elder law stuff, to get assets out of your estate. But typically, the trust will include some provision to amend the document, to amend the terms of it. Yeah.
okay. I guess I'm trying to figure out what my mother did. My mother had a trust, and she'd been married before to my father, and her husband made that trust, and he left everything to his 2 children, and left my mother's 3 children by a previous man out.
Mm-hmm.
And she was upset with it, but she felt like it was nothing to do with it. And
Yeah, I don't know. I'd have to look at the trust terms. I mean, I've been involved where same situation.
I mean, as a son, I give her advice. I said, call an attorney.
That's good advice. I agree.
That has nothing to do, don't go to the trust people, don't go to anybody you know, just pick one out of the phone book.
Mm.
And he took it, he looked at it, and he said, well, and this is for everybody in the room, he said, everything has to stay in the trust that's in the trust. But because there's checking accounts that my mother worked in and out of, he said the account has to stay, but how much money's in it does not. Because it didn't specify an amount of money in that account. So she was able to rework, I guess it was an unrevocable trust, into something more than what she wanted, leaving her children something.
Yeah, and again, I mean, all circumstances are unique. All trust agreements are typically unique. So I mean, that might be something that happened. I don't know. I don't know what that document says. But yeah, I mean, that doesn't sound unreasonable.
I have a question. If you have someone in your family that's totally not capable of caring for themselves or any finances, so would you set them up a trust, or would you set up something through your will?
It depends.
Would you do it either way?
I mean, so they're a special needs individual, I'm
Yes.
assuming? Yeah, so I mean, there's a special needs trust. Special needs trust, those are utilized to make sure that you're not endangering their benefits. They may be on a Michelle P waiver, they may be, they're getting Medicaid, Medicare, etc.
Would all that change when they become an adult, like if they're a child now, but then when they're an adult, everything changes? And so you have to redo stuff?
You have to set it up to where it doesn't affect their whatever they get from the government.
Yeah, I mean, basically you're setting up, you don't want them to get an influx of cash from you when you die. That's going to then endanger any needs-based programs that they're a part of. So think Michelle
Right.
P waiver, Medicaid. So, once they become an adult, I don't think your estate plan would need to change as long as you have those protections, but they may need to, do something on their end. So let's get into long-term care planning. This is the elder law portion. So again, there are different levels of care associated with long-term care. There's home care, independent living, assisted living, nursing home, and then a memory care specialty, and that's really kind of come on here, I feel like, in the last 5 to 10 years, memory care specialized units. In Kentucky, all levels of care other than nursing home care are private pay. So Medicaid's paying for nursing home. Everything else, you're probably going to be on the hook for. The majority of my presentation is solely focused on nursing home care. Okay, so I'm going to get that out there. That's the majority of this presentation. Just want to give you a look into what are the costs for nursing home and home care, community assisted. This is monthly median cost for Kentucky, 2020. I don't know what 2021, but with the rate of inflation, I'm sure it's gone up, right? So for a semi-private room in a nursing home facility, average median cost in Kentucky is $7,330 a month. That's a semi-private room. Private room is a little bit more expensive, $7,930. That's median. So again, there's a big spread. Here in Louisville, it might be more expensive. Might be less expensive for some. It just depends on the individual. But that's the median cost. So I mean that's pretty expensive, right? For really anybody. So a couple options: long-term care insurance. I mean that's an insurance product, right? Long-term care insurance may pay for the other levels of care, assisted living, home care, etc., depending on what the policy says. It can be pretty costly depending on your health and your age. It's like probably most insurance products, right? The older you get, the more expensive it's going to get. So this is the conversation to maybe start having with I don't know if most insurance brokers probably don't deal with long-term care. It's more of a specialized product, but you can just do a quick Google search, get in the phone book, and find probably somebody to that effect. There are some new hybrid policies that are coming out that provide like a death benefit if you don't use it, for example. So I think it's an evolving area because people have seen that it's almost cost prohibitive for people to get, so they're trying to figure out new ways to make it more available to other people. Talk briefly about Medicare. Medicare generally helps cover medically necessary services that can include long-term care. However, it's rarely an option for longer than a few months. So an example of this, in a skilled nursing facility care, Medicare Part A may cover meals, a semi-private room, prescription medications. However, from day 1 to 20, and this is assuming you've had a qualified stay in a hospital that's 3 days, and you have that medical necessity to go to the skilled nursing facility, maybe for rehab, something like that. Medicare Part A is going to cover day 1 through day 20. You're not going to be responsible for anything. Day 21 to 100, they're going to cover $185.50. 2021, that's going to go up to $194.50 in 2022 in a co-insurance type situation. So they're going to cover that portion, and then whatever above that you're going to be responsible for Medicare Part A. And then days 101 and beyond, it's yours. Now you may have supplemental, etc., that may change that. This is just basic Medicare Part A. So again, this is really not a long-term solution if you have if you're going to be in a skilled nursing facility for quite a while. So just to give you that context, and I'm not an expert on Medicare.
Didn't you say earlier that if you go into a nursing home, the government pays, but not totally?
No, I don't think I said that. Mm-mm.
Well, I must have. I wrote it down. Maybe I misheard you.
Depends on. I mean, if you're on Medicaid, yes, they'll pay for you. That's
qualify for one.
If you qualify for Medicaid, then yeah, that's a government-run program, but that's a need-based program. So we'll get into that here. So Medicaid is a wide-ranging. It's basically a state and federal program. It's run by the government. The focus of this are different types of Medicaid. Focus of this again is for elderly Kentucky residents. If you're a resident of Indiana, it's different. Age 65 and over. And this is specifically for long-term care, so for a nursing home. Medicaid is referred to as the payor of last resort. It's Medicaid is for those that are poor. That was the intention of Medicaid funding.
So if you're rich, it's gonna come out of your pocket till you become poor.
Unless you,
Or dead.
unless you engage in Medicaid planning, which we'll
Right.
get into. Medicaid is needs-based, and the rules differ state by state. Every single state is different. If you live across the border in Indiana, it's wholly different than Kentucky. In Kentucky, the Cabinet for Health and Human Services, Department of Medicaid Services is the agency that administers the state Medicaid program. They have offices all around, and the offices don't really talk to each other. I saw one attorney, he said, trying to deal with Medicaid is like trying to deal with the IRS, right? Don't go it alone. So Medicaid eligibility requirements, that depends on if you're single or you're married. There's an income limit and an asset limit. For a single person, an income limit is $2,382 a month. Asset limit is you have to be under $4,000. And we'll get into all this. So just this is general information. If you're married and only one spouse is applying for Medicaid for a nursing home, income limit is the same, $2,382. Asset limit, $2,000. And then community resource allowance, we'll get into that. We'll come back to these numbers, okay? So what do I mean when I say income? Income is from any source that the Medicaid applicant receives, it's counted, right? So any income that you're receiving, that means cash, veterans benefits, employment wages, alimony, IRA withdrawals, so the money that's coming into you require minimum distributions, think of that. Stock dividends, those are all counted as income. So to qualify for Medicaid, you have to be below that $2,000 and change dollar amount to qualify for Medicaid. If you're married, remember, only the applying spouse, their income is counted. So if you're married, and it's really, Kentucky follows the name on the check rule, right? Whose actual income is this? Is it mine or is it my spouse's? If I'm the person that's applying for Medicaid, they're only going to count my income, not my spouse's.
But your overall wealth is counted between both of you.
That's an asset thing. We'll get to that.
I got a question.
Yes.
Okay, it's not normally like this, but this is how it is. He has a job, he's working,
Mm-hmm.
he has income.
You'll be living
I'm
in
on
Florida, you
Medicare.
can't get cheap one as that.
And I've been on I'm on Medicare.
Yes.
Yeah, and I've been on it since '88. So, what would happen if he would have to go to a nursing home, or if I would have to go into a nursing home?
Two different things.
Whose income is out top of?
Well, I mean, it depends on whose income it is. If he's going into the nursing home, they count his, so his wages, etc. If you're going into the nursing home, they count yours, which if you're on Medicare, I mean, if you have any of those types of
His
cash.
income doesn't matter.
Not for income purposes, no.
Okay.
Now, if you're both applying, the rules are different. They're wholly. If you both have to go into a nursing home at the same time, then it's different. What are assets? We talked about that. So assets, there's a distinction under the regs between countable and exempt or uncountable, right? So countable assets are those things that are easily converted to cash to help cover the cost. So that's cash, stocks, bonds, investments, saving checking accounts, pension funds, real estate, and I'll qualify that a little bit, in which you don't reside. So if you have a rental property, if you have a condo, a lake property, they're going to count that as an asset. It doesn't matter whose name's on it. If you're married, they're going to count that as a joint asset, right? Kentucky has some pretty good exemption rules, whereas Indiana doesn't. So when Medicaid looks at your assets, they're not going to count one vehicle. So if you have two vehicles, they're not going to count one as a countable asset for you in your Medicaid. Irrevocable burial trust. So again, irrevocable burial trust, we kind of got into that a little bit. And then this is the big one for Kentucky, qualified retirement accounts in payout status. So Medicaid does not count your qualified retirement benefits as an asset for Medicaid, as long as it's in payout status. So whereas Indiana does.
So 401k,
is not
IRA.
counted for Medicaid purposes in Kentucky, as long as it's, qualified minimum distribution, or you're taking out.
So you're getting money from it. at the
You're getting
time.
money from it, but I mean, it can be $10. Whatever and if you're over a certain age, you have a qualified minimum distribution that you have to take.
Yeah.
But let's say you have to go in before you're required to make those required minimum distributions. As long as you're taking some money out, it's going to be exempt. So it's not counted. So that's, again, most Americans have their assets in their retirement accounts, right? So Kentucky does not count those, as long as it's a qualified retirement account, 401k, 403b, etc. They're not counting those for Medicaid purposes for your asset total. And then also your primary home, for the first 6 months, it's exempt. For the first 6 months, it's exempt, and then
Church, I can't talk right now. I'll tell you later.
and then as long as the Medicaid applicant resides in it, and then also gives an intention to return. So, and that's a letter that you tell Medicaid saying, I plan to go back after I get out of the nursing home. That is subject to a $603,000 equity limit. And if your spouse, if you have a non-applicant spouse, if they live in the home, it's always exempt, no matter what.
Oh, that's good.
So, for example, and we'll get into an example of this. My father's in really bad health. He's been in a nursing home in and out. My parents are married. So my mother in all this, she doesn't have to worry about the house being gone because it's not a countable resource for Medicaid. They have one vehicle, same deal, that's exempt for him. And then their retirement accounts are also exempt. So he can qualify for Medicaid on that. So, that's good for Kentucky. Now, again, these are state-by-state rules, right? Go across the border in Indiana, retirement accounts are counted.
So if you're a single person and you wind up in the nursing home for 7 months, now they're going to want your home.
You have to start listing it for sale.
Okay.
Now, it's not uncommon for somebody, after the first 6 months, you're supposed to sell. That's what Medicaid wants. It is not uncommon for somebody to have been in a nursing home for years and they still have their house just because they can't sell it, right? And you can kind of keep stringing, Medicaid along, but then they're going to do an estate recovery.
Now, if someone's living in it with like a nephew.
Doesn't count. It's spouse.
Spousal. Okay.
Spouse or disabled child.
I have heard of people going ahead and deeding their home to their children before they go into a nursing home. What is the time requirement on that previous?
7
Go on.
years.
5
5.
years. Kentucky has a 5-year look-back period. We'll get to that here in a second. Community spouse resource allowance. So
Back one second. That 6 months there, is that a one-time hitch or is that like a multiple hitch? In other words, you went in, you was in, say 6 months, and then you're out, you went back, with your intent to go home.
Mhm.
And then we'll say a year later, you're in again.
it's when you're applying for Medicaid. So if you apply again for Medicaid, it would be another 6
So
months.
that's each application of starting the situation, starts over each time.
Yes.
So
Okay.
this is only, it's only for a 6-month period then.
That the house is exempt from countable assets. So when you apply to Medicaid, they're going to do what's called a snapshot. And they're going to look at everything you own. So for the first 6 months of your institution, they are not going to count your house as one of your assets. Okay? But after that 6 months, they're going to start counting it. They're going to want you to sell it. Now, they're not going to stop your benefits, right? They're just going to say after you die, if you still own the house, they're going to come back after your estate to get your house.
Once you sell it, do they want all the money up front, or do you just expect to use it to pay your monthly cost?
I don't really answer to that as far as specifically, what happens at that point. Medicaid, again, the offices don't really talk to each other, right? And there's not really a uniform system. So, it could be, but if they find out you have an influx of cash, if you sold your house for $200,000, well, they're going to want you to use that to pay, right?
Okay.
So,
Are they
I
gonna
would
want you to
assume.
back pay?
No, because it's exempt at that point, I would argue.
Okay.
Community spouse resource allowance. So this is, again, if you're married Medicaid looks at your assets as jointly owned, no matter who has it. They've given a community spouse resource allowance. So in 2021, for married couples, the non-applicant spouse of a nursing home Medicaid applicant can retain half of the couple's joint assets to a maximum of $130,000. There's also a floor. Again, all assets are considered joint assets. So we'll get into it. We'll use some numbers. Just that's how I learn, right? So let's say you have a home. You're married. You have a home. The home is worth $250,000. Well, a home, if you're married and you have a non-applicant spouse at home, that's an exempt asset. So we're not going to count that. You have a 401k in Kentucky. Again, only Kentucky. It's exempt. We're not going to count that. And then one vehicle. So we're not going to count that. And this is all generality, right? There's different circumstances that maybe could switch some stuff in different categories. Let's say you have a second vehicle that's $20,000. You have checking and savings, $120,000 between both spouses. Non-qualified investments, so you just have a, investment account with somebody that's not a qualified, not a 401k. And then you have a $20,000 CD. So total countable resources are $280,000. So the community spouse resource allowance in Kentucky, again it's different, says that the non-applying spouse can keep up to half, which would be $140,000. But there's a max of $130,000, $380,000. So that's saying that the community spouse can keep up to $130,000 of their $280,000 countable assets. The nursing home resident can have $2,000, so you got $2,000. So that means in this scenario, Medicaid would require you to spend down $147,000 of your assets before you could qualify for Medicaid. Does all that math make sense? We can go through it again, but that's how the community resource spouse allowance fits in.
If you didn't have $120,000 in checking and savings, then your total accountable assets would be $160,000. Anyway, whatever your spend down point becomes, what if it exceeds? Would you ever have to dip into your exempt things to reach that point?
No, they're only requiring you to spend down your countable assets. You don't have to touch it. Now let's and I don't have a slide for this, but let's say you take out. You don't have any checking or savings. You don't have any non-qualified. All you have is a $20,000 car and $20,000 in CD between the two of you in countable assets. Well, that's only $40,000, and half of that is $20,000.
Right.
There is a floor, right? So they don't want to leave one spouse completely impoverished. It's about $25,000, so you can keep up to that amount, right? They're going to let you keep more than the $20,000.
Okay.
Up to that amount. So, but no, you wouldn't ever have to spend down your exempt. You just have to spend down your countable before you can qualify for Medicaid, right?
Okay.
Because they're taking a snapshot at your assets.
Gotcha.
Right. We talked about people gifting their property to their kids. Kentucky has a 5-year look-back period. Medicaid says if you give away, sell anything for less than fair market value, they're going to assess you a penalty. It's called a divestment penalty. They don't like that. They don't like when people do that, right? So if you do something today, so let's say you have children, you gift your house to your kids today, and then you do not go into a nursing home for 5 years and a day. Doesn't matter. Medicaid's only looking back 5 years, right?
Right.
Now, if you did that and then you did have to go into a nursing home in 2 years, let's say, they're going to look at that transaction and say, well, you gave away a $100,000 house for free. So we're going to assess you a penalty. Kentucky's, this is different by state. Kentucky's is $199.46 per day divestment penalty. So basically, you divide what you gave away by that penalty. That'll give you the days that you're ineligible for Medicaid. So in that case, let's say you gifted your 6 grandkids $15,000 each. So $90,000. Well, you gifted them all this cash that you had. Medicaid's gonna see that as you gave away your money. You could have used that to pay for a nursing home. So they're gonna take that $90,000, they're gonna divide it by $199.46, which you're gonna be ineligible for Medicaid for 452 days, so over a year. You're gonna have to figure out how to pay for it.
Don't wait.
So, yeah.
So that means you're paying the 452 days, you got to pay that,
Yeah, you gotta figure out something, right? Yeah, you gotta pay it.
or do without.
I had a client who they had, their mother was from California, bought a house back in, I think it was Berkeley or somewhere, back in like the 40s for $30,000. It's worth 1.5 million now. She wanted to sell that and then give it to the kids. Well, I mean, the Medicaid penalty on her was going to be like 20 years or something,
Yeah.
So it's just like, well, you just use your money to pay for 5 years, and then it's, you don't have to worry about it anymore, right? So, that can be, I mean, that's a very common circumstance where the amount that you've given away incurs a penalty for longer than 5 years. In that case, you just need to use the funds, however you have it, to pay for the 5 years of private pay of nursing home if you have that. And then after that, you can qualify for Medicaid because you don't have it, you gave it away, right? So this is a 5-year look-back period. For example, my grandparents back in the 90s, we have a family farm where I'm at. They gave my mother and her siblings the farm because they were concerned. They didn't want it to go to Medicaid, to the state. Once they died, they had to go to a nursing home. So that was back in the 90s. They're good now, right? My grandparents are good. Medicaid is not going to see that as a penalized transaction.
Because it's more than 5 years.
Because it's outside 5 years. Yeah, if they did it today, and then next year they had to go to a nursing home, there'd be a penalty, right?
Well, I had it all set up, and the time was doing good, and my son died.
Hmm.
He was mentally challenged.
Mhm.
Now I got to start all over
Yeah.
again because it died when
Mhm.
I had a revocable trust,
Mhm.
and I set it up so Uncle Sam couldn't take any of his benefits away from him.
Mhm.
Now I got to start all over again.
Yeah, so again, every situation is unique.
I didn't have much but my house,
Mhm.
but I was trying to protect him.
Yeah, and it constantly changes. I mean, that's more special needs planning, not necessarily Medicaid planning, but I mean, they kind of go hand in hand. They apply a lot of the same rules. So, Medicaid planning, when I use that term, it's about preserving assets, right? Typically, the sooner you begin, the better the result. I mean, typically. And don't go it alone. Again, it's like talking to the IRS, which I do quite often, and it's miserable. It's like running my head through that wall right there. So, I'm not going to get into specific Medicaid planning strategies. There are certain things you can do. You can put stuff in irrevocable trust. You can get certain annuities that are qualified under statutes. You can get you a nice car, because one of those is really about taking countable resources and making them uncountable for Medicaid. And then there's also the discussion, should you use your own money to pay for your own nursing home? I get that. I get that conversation. So, but there are ways to plan, and the sooner you start doing it, the better. Especially in this, the cost of a nursing home is only going to go up, as with everything. So it's going to get very expensive. And those are only Kentucky numbers. If you're anywhere else, they can be more expensive. So that's all I have. Again, just a 30,000-foot view of everything. Threw a lot of stuff at you. I understand that. Really, what I can leave you with is you need a will, you need a power of attorney, you need a living will, you need a medical power of attorney, healthcare surrogate designation. And those are the documents you really need. And then if you really want to talk about Medicaid and you're concerned you may have to, nursing home is in your future, you need to start planning now. I'll just open it up to general questions.
Well, first off, anybody wants to make an appointment with you?
Yeah, I have cards right here. You can, best way is just call or email. We'll set up a time to get you to come.
And your
to
offices are located where?
They're in LaGrange, Kentucky, but I have office space I can use in Louisville if need be.
Okay.
Do you have this information in general that you've shared with us in print?
No.
Because nobody's gonna remember what you've said entirely.
Well, I can't forget it.
I was gonna ask the same question.
No, I don't, but if you email me, I can email you the documents. I don't have it currently, but we can figure it out.
'Cause there's
Is it
a,
all on that website?
No, that's just my firm website.
Okay.
because the lady that just called me couldn't make it tonight, and she was wanting to know if you
Yeah,
could send her something.
yeah. Again, it's a lot of information, and again, every person's situation is unique. I don't know what you have, and attorneys will probably counsel you different ways, on different ways. Some attorneys really push revocable living trusts. I typically don't. The probate process in Kentucky is not that scary. It is public. Some people don't want, people being able to know what they had when they died. I get that.
What's the difference in Medicaid or Medicare?
Well, if you're 65, why do you need Medicaid is what we were.
Well, Medicaid is for impoverished, individuals. I mean, besides the difference, again, I'm not really a specialist on Medicare. So I would just talk to those folks.
But it wouldn't cover nursing home.
But Medicare typically does
Long-term.
not cover long-term care past the 100 days. Really, past the 20 days, you're good. 21 to 100, they're paying a co-insurance on it. And then after the 100 days, you're paying everything anyways. So then at that point, that's probably when you need to start considering Medicaid. Which is what we did for my father, for example. He was in a nursing home. He was nearing the 100-day mark. But luckily for us, he was able to get better to the point where he was released to come back home, so we didn't have to have that conversation. The other part of this whole discussion too is plan first. Don't just say, "Oh my gosh, I need to spend down $150,000." Right? Not saying you probably would, but you need to talk to a professional first. If there's certain things you can do if it's a crisis situation, if you haven't really thought about this, but dad needs to go into a nursing home tomorrow, there are some things you can do to help preserve some assets, some money. Probably not everything, but there are certain things you can invest in, annuities type situations. But that would be the answer to that. I think Medicare's not really covering your long-term care past that 100 days.
So if someone does want to meet with you, I guess they should call first so they can explain why they want to meet, and you can advise them what documents to bring in.
Yeah, I think that'd be good. If you have a previous will, again, you can always amend a will while you're alive. You can also do a codicil. Some people might have heard that term. I don't do codicils because it just gets so confusing when you have a will and then you have 5 codicils on it. You kind of have to match it up. What did they revoke? What didn't they revoke? It gets real confusing. So I always just do a new will. Any old documents that you have, if you need to update some beneficiaries. The other conversation too is, do you have retirement accounts? Do you have life insurance policies? Making sure your beneficiary designations on those are correct, going who you want them to go to. Those are always part of the conversation too. So.
Maybe I missed this, but what about your life insurance? Can they go back and after you pass away, if you've been on Medicaid, can they go back and
Depends on who the beneficiary is. If there's no beneficiary and it just goes to your estate, yes. If you've named, somebody else, they're generally not going to try to go. I've never seen them go after that. I think the regs say that they can, but they don't. But if same for the house. I mentioned the situation is not uncommon for someone to be in a nursing home for years. They've tried to sell their house, or they've tried to sell their house, but not really. And then they have a house in their estate. Well, Medicaid, they probably would file a creditor claim in the estate at that point. But Kentucky, at least in my experience and what I've talked to people, Kentucky's not the most diligent in estate recovery. They're only really getting like 1% of probably what they could. But you don't want to be the 1%, right? No, that's the question.
Can they go back and get anything from the prescribing spouse?
As far as what their community
Well, like
resource
assets,
allowance and stuff.
Assets and anything like that?
No, typically not. I mean, that's
I mean,
their,
we'll just say at filing date here at this point, but at some other point, you go above these limits that they have.
No,
Are they
it's
gonna
a
come back
snapshot.
and- Are they gonna come back and get,
snapshot. They take a picture of your assets at that date. So if your spouse will get a play in the stock market and hits it big, you know, they're not gonna care on it.
Right.
Just,
I want to go back to, you made a statement that I'm not real clear on is, you must be taking a distribution from a retirement account
for it to be exempt.
for it to be exempt.
Right. So, you know, Kentucky has a really good rule that says we're not gonna count that and it's exempt from Medicaid asset requirements. But I think they do add that it has to be, so, you know, if you're certain age, you're required to take those required minimum distributions. That money is income for you. So if you're, you know, that, you have to be below that. But other than that, they're not gonna count the rest of it. You know, if you have $500,000 in a 401k, if you're getting the distribution from it, that's income, but they're not counting the whole $500,000.
Is that a regular recurring distribution? And what if you just called up your broker and said, give me $100 out of my 401k?
I think it's monthly, is what,
Yeah,
I think is
monthly.
what the
Yeah.
Medicaid.
at
manual
age
says.
70, you have to have an exit program in place?
70,
right?
yeah, 70 and a half.
But you can take it out only just once a year, you don't have to take it out a month.
I think Medicaid, their manual, I think, wants you to maybe do it monthly, but yeah, I mean, the required minimum is just, as long as it's a yearly thing, yeah. But I mean, that's, goes to the exemption, right? They're not counting that $500,000, which that's a benefit for being in Kentucky, honestly. A lot of states don't have that. Indiana doesn't have it. They're counting the whole thing and they want you to spend it down.
So if you're not taking a distribution, then it is capturable?
Yeah, but just take $10 out of it, right? Then it's
Every
in,
month?
then it's in payout state. Well, it just depends. I'd have to look
Okay,
at the specific
okay.
situation, but I mean, you know, I would argue, I'm a lawyer, right? So I would argue that you take $10 out of it. What's in payout status? I mean, I got paid out of it, so you can't count it. I'd be willing to fight that case for you. Any questions? I appreciate it. Again, cards are up here. Thank you all.
Thank you so much for
Thank
coming.
you for your time.
Thank you.